Yeah, the only observer.
The only observer?
Yeah.
Is there another South Florida attorney that's actually representing, or trying to represent these folks?
No, who I was thinking of actually is that one of the prosecution members used to be an assistant U.S. attorney here.
Who's that?
Ed Ryan, who's now an assistant U.S. attorney in Charlotte, North Carolina, but he's been detailed to the prosecution team.
Now, how did you come about your role for the ABA?
Back in 2002, I was asked to chair a task force on treatment of enemy combatants. It was after the Padilla case had gained some notoriety, and we put together a task force of people with experience in the area that I had the honor of chairing, and did a report to the House of Delegates. In the ABA, policy is adopted by the House of Delegates, which is a 560 some odd. I can get the exact number for you. I should know it. It's the legislature. The ABA is Congress, and before something is adopted as ABA policy, it has to be approved by the ABA as the House of Delegates. So the first thing that we did was to take a report with recommendations to the ABA House of Delegates dealing with how, in that case, U.S. citizen enemy combatants should be treated, because Padilla was the only one that was at issue at that time. There were a couple of others that surfaced later, and then, of course, all of these folks at Guantanamo. And then the following year, we did a report on recommendation from the House of Delegates on the use of civilian defense counsel in military commission trials. By that time, they had set up the military commission structure, and I think it was 2004 where they had the first hearings. But prior to that time, we were very much dissatisfied with the rules for civilian defense counsel.
In which way?
It would have required civilian defense counsel to act against the rules of professional conduct. They would have had to waive attorney-client privilege in many matters. It was very difficult for them to qualify to become civilian defense counsel. The only civilians who are going to volunteer are people who are going to do it pro bono, or in some cases be paid fairly minimal amounts by foundation grants.
So, in which way did they want you to violate the attorney-client privilege?
You had to agree that your conversations with your client could be overheard, which is a clear violation of attorney-client confidentiality and the attorney-client privilege. You were not allowed to talk to your client about anything that was considered secret information. You were not allowed to consult with other counsel representing other clients. I mean, there was a whole raft of things.
How do you know which is secret information even when you're discussing it?
The government says it is.
Oh.
And and now what the government has done is anything a detainee says is presumptively secret. So it makes it very difficult. And I prepared a care package for you.
Oh, great. What is that care package?
And one of them is I think I have these in order. The first policy that was adopted by the ABA goes back to February of 2002, which is actually before my task force was started. This was done, I had a hand in writing this, but it was done by other entities. And this is the one that said if you're going to try these folks, you've got to try them under the UCMJ, and you've got to require the provisions of the UCMJ except for Article 32, which is like their grand jury.
And the UCMJ has one judge, correct?
The UCMJ has a judge per, for each case.
Right.
Now, if you join defendants together, then several defendants can be tried by one judge. It's not the number of judges; it's the rules that are followed. The UCMJ, the Uniform Code of Military Justice, largely follows the federal rules in terms of what evidence can be introduced, in terms of the ability of lawyers to prepare, in terms of the role of civilian defense counsel. Under the rules that they had established, civilian defense counsel could be barred from any proceeding where there was secret or top secret evidence. The only lawyer who could remain would be the military defense counsel. So this was this was the first one that we did that was directed at Padilla. This is February 2003. And then in August of 2003 was the one that we did that was overwhelmingly approved by the House of Delegates regarding civilian defense counsel. And it should not monitor privileged conversations, should ensure that they are permitted to be present at all stages of the proceedings, and other recommendations. Now, in point of fact, the rules were changed as a result of this. So the ABA made some progress, and I had negotiations with representatives of the Defense Department as well that resulted in some of these rule changes.
The ABA has their own lobbyists, and they take this to congressmen and lawmakers?
Yeah, we have a large Office of Governmental Affairs. I wear another hat. I also chair that committee, the Standing Committee on Governmental Affairs. But we have a couple of dozen Government Affairs Council. So once the ABA House of Delegates approves a policy, then the ABA's lobbyists, legislative council, can advocate in the Congress, in agencies. We write letters to the President, to the Secretary of Defense, depending on what the issue is.
What changes were adopted? What kind of out of this report?
They changed the worst of the rules, those that would have allowed for overhearing or monitoring of conversations. They made it easier for people to become civilian defense counsel. Originally, they proposed